Person gets on the line with me and introduces himself as an FBI agent. And he says, I understand you're getting ready to bring a claim against so-and-so. And I said, yeah. And he says, we want your file. That phone conversation, I tell him I'm not giving my file, attorney-client privilege, that. And he just says, son, we're the FBI. We'll be at your office this afternoon.
No way.
Yeah.
All right, everybody, welcome to another great episode of Cases Gone Wild with me, your host, Jon Marko, brought to you by none other than Marko Law. We have a great show for you today. We have a great guest, a very accomplished attorney who has all kind of crazy, wild cases that we're going to talk about. Remember, you can watch us online on video on our YouTube channel or go to the website, markolaw.com. And you can listen on all your favorite podcast platforms. Today we have a great attorney, a great guy. In fact, one of the first cases I ever handled on my own was against this guy, and I didn't do too well back then. We have Michael Dolenga on the show. Mike, thanks for coming on the show, Michael.
Good to be here, John. Thanks for having me.
Good to see you, man. Do you remember that case back in the day?
I do. That's a long time ago, but I can remember it. Yep.
Yeah.
We had some battles.
We'll have to throw some tidbits out from that. But Michael works with his wife at Dolenga and Dolenga. You've been practicing for, over 30 years?
Yeah, just over 30 years.
Very accomplished career. He's very well respected in the community. I know that you've been doing a lot of mediations as of late for the last decade maybe, or how long?
Little over that, yeah. Litigating for 30 years, mediating, arbitrating, and about 10 years ago, people asked me to start and get involved with their mediation, see if I can help them resolve some cases and get rid of some of the crazy stories and all the crazy trials and just kind of make them go away. So I'm doing a lot of work as a mediator the last 10 years.
I heard you settled like over 1,000 cases or something crazy like that.
It's hard to keep track, but it's definitely over 1,000 at this point.
Yeah, well, that's good, man. I mean, we need good mediators. And you're great. I've used you as a mediator before. Didn't always get what I wanted, but hopefully neither did the defense. That's usually the way it's supposed to work, right?
Exactly. They say that's always a sign of a good settlement, right? When everybody leaves unhappy, the case is settled, and that's an okay thing.
That's right. Well, thanks for coming on the show. You graduated from DCL, and you've kind of had a illustrious career. You told me you started as a plaintiff lawyer. Tell our viewers a little bit about your journey to how you became where you are today.
Sure. I actually started working when I was in law school, and so I switched to the night program, started working full-time, and was just kind of ready to go, and was lucky enough to get a job at the place that I was law clerking at. So I worked there for a couple of years as a plaintiff's lawyer doing plaintiff cases, and then switched over to a different firm where I handled plaintiff stuff and defense stuff, and then over time my defense practice built up quite a bit, and so I've always done plaintiff work and defense work my whole career, but more and more on the defense side as things have gone on. And like I mentioned more recently, people knowing me from both sides of the V, if you will, have asked me to get involved with mediations and arbitrations and things like that. So I'll sit as an arbitrator and decide cases for people. I'll work as a mediator and help people resolve cases.
Well, I think that says a lot. If I said, Jon Marko, I'm going to start mediating, I don't think I'd get any business. I think the plaintiff's lawyers would like to use me, but I think maybe because of my litigation style or whatever it is, let other people judge, but I think it would be a hard sell. I have a known bias that I've let known on the show, and I let know in my life that, I'm a plaintiff's lawyer. I'm a man for the injured people. And so I don't think I get much business from the defense side. I think to become a mediator, and the good mediators that I've seen like you have a certain tact and a certain level of respect on all sides.
Thanks, John. I appreciate that. And you really have to understand to be a mediator. You really have to know what, people that are injured, they've lost a loved one or they've been severely injured, what they're going through. And there's a certain way to talk to them and empathize with them and understand what they're going through. And on the other side, there's people that have been sued, rightfully, sometimes wrongfully sometimes. So they're going through a lot on their side too. They might have some different business making decision models and things like that they use, but they're going through a lot too. And so you got to be able to talk to them about that and understand what both sides are going through. And bring some compromise to both sides, let them understand their side a little bit better. And like I said, sometimes they're happy, sometimes they're not so happy, but it works.
You probably don't remember, but 15 years ago when we had a case, it was one of the first, it was the first medical malpractice case that I had ever worked on. And I filed the lawsuit, the complaint. And, in our complaints, we list all the facts, the basic facts. And you personally called my office. And, normally it's very adversarial, especially when you're young, because when you're younger too, you're a little more nervous. At least I was. So
and a little more aggressive sometimes.
A little more
too.
aggressive, right?
Yeah.
To make up for your insecurities,
right.
You called and you said, hey, I want to let you know that there's a mistake in your complaint. You have a date on paragraph 28 and you have the wrong date. It's not critical to the case, but I just wanted to let you know in case you needed to fix it. I never forgot that. I really didn't. That's a true story. And I just remember because 99% of people wouldn't have done it. It wasn't case dispositive. In other words, it wasn't going to make a difference in the case in terms of a gotcha or anything. But you had the courtesy to do that. And that little tiny thing stuck with me. That little, I don't know if I'd call it an act of kindness or whatever, but that really stuck with me.
Yeah, I've always thought that, there's times to do battle and there's times not to do battle. And I remember that case. I don't necessarily remember that phone call, but that sounds like something I would do because it's a little issue. You might need to fix it. The judge might catch it, make you look bad, something like that. But it wasn't going to matter a whole lot by the end of the case. There was much bigger issues in that case, and there was
bigger issues.
A lot of time to fight about those bigger issues, and we fought about those and figured help you out a little bit in the beginning.
My client had, she liked cocaine a little bit, and she had a heart issue, and whether or not the cocaine contributed to it was a debate. But you litigate that case very well, and do you remember that deposition? We had to go down to Toledo or wherever it was, Cleveland. No, it was Cleveland, Ohio.
Yeah.
And we had, so again, being young and being one of your first cases, my secretary did not secure a court reporter. So when you do a deposition, it's like cross-exam, right? And there's a court reporter that types everything down. And we get there and there's no court reporter. There's no location for the doctor because we were deposing a doctor down there, my expert witness. And so we scrambled. And so I talked to this doctor and I said, Doc, I'm sorry. I'm young. I'm doing the best I can. We screwed up. He's like, don't worry about it. Come to my house. We're going to do the deposition at my house. He had this beautiful mansion outside of Cleveland. And we get to the dep and we find a court reporter. And he says, you know what? It's a nice day. Why don't we do this whole deposition outside on the patio overlooking like his garden with waterfalls and all this stuff. And we're out there doing deposition, rolling up our sleeves. The sun's out. And I'm like, man, this is what it's like. It was like out of Suits or something, you know?
You figured every deposition would be in this beautiful setting, right?
Yeah, right.
Yeah. Since then, there are hot conference rooms, dingy offices. I've taken depositions inside of motorhomes.
Yeah, right. Yeah, with like Maxwell House coffee and all this. And it was really nice. And then, so we're there sitting in the middle of the day, about an hour in, the door opens to the house, and this beautiful woman comes in wearing scrubs. She has, and she starts making lemonade. And I'm trying to pay attention to the doctor, but I keep looking at this woman who's wearing these like tight scrubs. And she comes out with this big pitcher of lemonade and places it on the table, kisses the doctor on the cheek. And he's like, oh, thank you, honey. It was like the nurse he was dating from the Cleveland Clinic or whatever who was there. And I'm like, this is it. I've made it. This is what I want to do, you know?
John, I feel like a lot of your stories when you were a young lawyer turned out well. I can tell you one of mine that didn't turn out so well for me if you want.
Your cases gone wild. So.
Yeah, this was a wild one, and unfortunately it was a good learning lesson for me. But it's one of the very first cases that I ever handled. I was working at a plaintiff's lawyer, working at a plaintiff's firm, and we had this really tragic case. It was a young man that was working for this company, and his job was basically to do a lot of different things for this company. He had to build stuff. He would take things down, and then he would actually move the equipment from one location to another location.
Like heavy machinery? Or?
Yeah, heavy machinery stuff. And they would do this usually like in caravans. So they would have like several semi trucks together, going from one location to another. And on this particular night, they finished at one location. They loaded up all the trucks. This is, back in the 90s, so they didn't have Google Maps and all that kind of stuff. But they got together. They planned their route. They said, well, we'll stop for gas here. We'll stop for this restaurant here along the way, and this caravan of vehicles eventually several hours down the road.
Excavators and stuff like that?
Yeah, excavators and big equipment, stuff like that.
What I didn't realize is how they have to plan for the highway overpasses.
Right.
I don't know if that's where this is going or not, but
yeah.
It's crazy.
This one, unfortunately, comes to a T intersection.
Okay.
And so this young man, he's like 23 years old, working hard for this company, and he's driving down this road, and he's coming to this T intersection. He hits the brakes, vehicle starts to stop a little bit, and he's in this big semi truck, and not enough, and he tries to hit the brakes again, tries to slow down again, doesn't slow down enough, and he hits this T intersection going way too fast.
T intersection, so there's like a stop sign, and then there's traffic going the other way?
Exactly. And so, of course...
And your guy's driving the truck?
He's driving the truck,
okay,
hitting the brakes, and the truck's not stopping.
Did the brakes go out, or what was going on?
That was our theory of the case. So he manages to not be able to, to get through this T intersection. Semi-truck flips on its side, and he gets trapped because of the way the truck is sitting.
Oh, my God.
Truck starts on fire.
No way.
Yeah. He's trapped inside. He can't get out. One of the other vehicles coming this way, the guy jumps out. He's trying to help him out of the truck. And it's just a horrible story. He's pulling on the door, trying to open up. The guy's inside yelling, "It's getting really hot in here. It's getting really bad. Please help. Please help."
And the truck's literally on fire?
Truck is on fire. There's flames coming up.
And he's locked in the cab?
Locked in the cab. Hotter and hotter. This witness says, I jumped down. I'm throwing dirt on the truck, trying to get the fire out.
Oh, my God.
I cannot get the fire out. And this young man, unfortunately, burnt alive inside the cab of this vehicle.
Oh, my God. I can't think of a worse way to go than to be trapped inside a cab, knowing what's going on, and then burning alive in there.
Yeah, exactly. It was awful. So my law firm filed a lawsuit against the manufacturer of the semi-truck that he was driving, alleging that the brakes were defective. We had an expert witness saying the brakes were defective and all that. As a young lawyer, my job was kind of to do a lot of the housekeeping, keep track of the witnesses, manage all that stuff. And so
some of the hardest work out there, man.
Exactly. One of the key witnesses for us was the person who was right behind the truck. Was a good friend of the young man's, and he was going to come to trial and testify for us and talk about how he saw the truck start to slow down a little bit, but then it couldn't slow down, and then tried to slow down a little bit more, and it couldn't slow down, and then he witnessed the whole fire and all that. So he's a very important witness for us and for our expert.
Yeah.
So I stayed in touch with this guy for a year and a half. We're finally ready for trial.
Did you depose the guy or no?
He was one of those unique situations where we knew his testimony was going to be good for us. So my boss made the tactical decision not to take his deposition.
Yeah, and there's I've done that before. I do it a lot, but it's also a balancing act because if you have a key witness, like I just had a case involving heavy machinery, one key witness, okay? And, you have to make the decision. Do we want to depose him and preserve his testimony? Because if he dies, gets sick, goes AWOL, you're out of luck.
Right.
But at the other hand, if you can go to trial, that's like the ace up your sleeve, right? Like you play poker with the ace up your sleeve, that's it.
Right.
So, right. I mean, it's always a judgment call, so I can't blame your boss for that.
Right.
So what, sorry to interrupt, so what happened?
No problem. So my bad outcome, though, in my case gone wild, is that about 3 days before the trial is going to start, I'm talking to the witness again. Boss says, make sure you get him there, go through all the testimony. He's talking about, the truck and it couldn't stop and the burning cab and all that kind of stuff. And said, okay, so Tuesday morning, 10 a.m., we're going to put you on the stand, all set. Yep. Are you going to be there? Yeah. Do you need any help getting to the courtroom? You need me to come pick you up? He says, no, we're good. I'm good. The other lawyer made arrangements. They're going to come get me.
No.
Yeah. And I said, what? The other lawyer's going to come get me. Well, the other lawyers, you've been talking to the lawyer? So, yeah, he's been calling me all along just the way you have. And I said, well, why? I have no idea. He wants me to testify. You want me to testify? I said, well, let's go through this story again. And he tells me the whole story. They got ready. They stopped here. They stopped there. I said, did you tell this other guy anything you didn't tell me? And he said, no, not really. Well, he asked me a lot more questions about all the marijuana we were smoking that night. And I said, what? And he said, yeah, well, we stopped at the restaurant. We smoked some weed. Stopped at the gas station. We smoked. I said, even the guy that was in the truck that we're representing and you? He said, yeah, behind the restaurant, we smoked a bunch of pot. And so apparently the guy that came to the T intersection that couldn't navigate it, he was higher than a kite at the time that the accident happened as well.
So were the brakes defective?
Well, fortunately for us, we still had a lot of that stuff lined up. And so, we think it ended up being a combination of defective brakes and possibly our client having a little bit of weed. A little bit of impaired judgment and impaired ability to manage that current. So that was not a good story that I had to go tell my boss, but I did. And we managed to negotiate a settlement before the trial started.
Because you found that out, but you found that out a couple of days before trial.
Right before trial, after a year and a half of litigation.
That's a dangerous way to, that's the disadvantages of playing it like that, right? Now, if you had deposed this guy, you would have known what he would have said, but so would the defense have known what he would have said, right? So I always try to balance. I feel like today the tendency of most lawyers is better safe than sorry. I don't know. What do you think?
Yeah. Depends on the case. Depends on the facts. Depends on the case. But generally speaking, better safe than sorry. Yeah.
Yeah. If you know a case is going to trial, you might handle it differently than if you're trying to settle the case, right? Like if you're trying to really settle a case, I think it's important to depose the person and let it rip more than if you know this is going to go to trial. Sometimes you got to save some back. I always tell people,
right. Yeah, I agree. Cause you want to you have a lot of different theories that you're trying to put forward with the case, a lot of different tactics that you're going to use. And so sometimes you want to take all the depositions because you're trying to force this to happen. Sometimes you're trying to force something different to happen. So you wait it out. And sometimes you got to shift and change those theories along the way too.
Yeah. Well, also weed was a lot worse in the 90s than it is now. I mean, I remember if it was like weed, in the 90s, it was like devil's weed.
Right.
Your case is over. Your client smoked reefer. Now it's like, Right.
Except for the driving part.
Except for the driving. It's not good. But I don't know. I think, what do you think's worse if you're a plaintiff's lawyer? Your client's drunk driving or your client's high on marijuana? Neither of them are good.
Right.
But personally, I'd rather have my client be clean. But if I had to choose, I'd rather have a person who's high than drunk. On weed. I mean, I'm not talking like, I don't know, acid or something,
Either way, it's going to cause a big problem for your clients and good benefit for the defense, I guess.
Yeah, for sure. Yeah. I mean, I had a trial that I did recently where in Oakland County where my guy was a huge pothead. I mean, he was like a yogi type guy. He smoked weed probably every day, and he had a medical marijuana card. And I tried to keep it out. He wasn't high during the accident or anything like that. He was hit head on. It wasn't his fault. They admitted liability, all that. But it was just something I was worried about. And so I talked to the jury about it in voir dire beforehand. And there was like an old time cop, and he's like, I don't like that, and I'm biased against your guy for it. I said, thanks. We got him off.
Right.
And then there was a lot of other people who said, I don't care. I smoke weed every day. So,
interesting.
But it's interesting. But I don't think it's as polarizing as it used to be.
Right.
But I don't know. What do you think? You think the same way about that?
No, I don't think it's as polarizing as it used to be.
Not good though.
Yeah. You mentioned admitted liability. I can tell you a story about that too, because I don't want your viewers to think I've had all bad results in these cases either.
Yeah. But it sounds like maybe you didn't have a bad result in that. You resolved it.
That's true. We
it wasn't the result you were hoping
it probably
for.
ended up being a fair result at the end of the day, right? We didn't know all the facts, and we didn't know that. Once we learned all the facts, and they couldn't totally make the case go away, so it ended up in a fair result.
Yeah,
Good
for
point.
sure. For sure.
Yeah.
So admitted liability. This is always a big issue. I hear this all the time in mediations now.
Yeah.
And just so people understand who aren't in the law, tell the idea of admitted liability.
Yeah. So in every tort litigation, there's multiple elements that the plaintiff has to prove. There's liability, there's what we call proximate causation, and then there's damages. And so you got to get over every single one of those hurdles before you can get one of these big judgments that Jon Marko gets. So the liability aspect of the case, sometimes the defendant can defend that a lot and they can win on liability.
And that's like boils down to, did somebody do something wrong?
Yeah,
unreasonable.
Exactly. And then the causation part is, did them doing something wrong caused some problem or some damages or some injuries. And of course, the damages and injuries part of the damage part of the case.
Yeah, yeah.
So a lot of lawyers, if they have a case that are having a hard time defending on the defense side, they'll talk a big game. They'll say, well, we're just going to admit liability and then we'll go win on causation and damages. But not a lot of them actually have the guts to do that, because once you win on liability as the plaintiff, the plaintiff's lawyer is going into court saying, it's not a matter of how big of not a matter of whether I'm going to get a judgment or not.
How
it's about
much?
how big that judgment's going to be. Right.
So it's like the defense admits we made a mistake. We did something wrong, and it's just a matter of how much, essentially.
Right, exactly, right. Or if you can win on causation alone, you can still get that zero.
Sure.
But it's really tough and doesn't happen very often.
It's hard to do.
I've been lucky. I've had it happen twice to me, where I admitted liability with my client, defended the case on causation, and the jury came back with zero on both cases.
So they were like, what kind of cases were they?
The first one was a product liability type case, and the second one was a medical malpractice case. So
in both cases, you said, as a defense attorney, you were defending the people getting sued.
Yes, exactly.
And you said, I'm going to admit that we screwed up, essentially.
Not quite in those words, but yeah.
I mean, essentially, right?
Yeah.
And we need to be reasonable. What's the damages?
Right. In the first case, it was a product that my client had essentially put out in the stream of commerce, and
what kind of product was it?
It was just not. Can't tell you that because I don't want the client to get in any trouble. But it was not a well built product. Let's just say that.
Okay, and it hurt somebody.
Yeah, didn't actually hurt somebody. Just it was like a couple $100,000 product, and it had so many problems that the people that bought it ended up suing, saying we want our money back. Like you sold us this complete hunk of junk,
thing?
right?
Yeah.
And so the plaintiff's lawyer was convinced that, with as many problems that product had, it had, after they, bought it for a couple $100,000, they had like $30,000, $40,000, $50,000 worth of repairs that had to be done on it to fix it, to get it, back into decent shape. And so we went to trial and we said, we put a bad product out there. This particular product had come with a warranty as well. So we came up with this theory that every time that they complained about the product, my client stepped up and did all the repairs to it and fixed it for them. Unfortunately, it took like 10, 15 times of that happening. And in the closing argument, of course, the plaintiff's lawyer argued, they've admitted wrongdoing. They admitted they put a bad product out there, and just a matter of how much, give them all their money back for the product. In my closing, I argued kind of the opposite, but, kind of apologized to the jury, explained to the jury that my client had already apologized, and said to the jury, you could give them all their money back. That's part of the element of damages. But it came with this warranty, so you could also give them less money. You could give them a diminution in value, for example. And we had called experts to say that product may not have been the best, but the diminution in value was not very much because my client stepped up and fixed it.
So like the product should have been worth this much. Don't give them the full money back. Say
Exactly.
like basically it wasn't the Porsche of cars or whatever this thing was.
Good example.
It was the Ford of cars or whatever. Not
Exactly.
to disparage Ford, but it wasn't the high end, and so give them like a diminished value, a reduced value. Yeah.
And then the other way you could assess damage is cost of repair. And so this was our best argument. I argued that it had $50,000 worth of repair on it, but since it came with a warranty, the customer was actually charged zero of that and didn't have to pay any of that out of the pocket. So I argued you shouldn't give them anything because even though they got
Still
a bad product, we fixed it.
Nobody likes those warranty
I know
claims,
that, and that was the big risk. That was a big risk.
What did the jury do?
Jury believed us, and they said no causation, and they returned zero. Yeah.
Big fat zero.
Yeah.
So see, I'll tell you a secret, okay? As a plaintiff's lawyer, I hate it when the defense says, we admit we were wrong and we're sorry, because it doesn't happen very often, and it makes my job a lot harder. Right? Because part of the reason that I think we can get big verdicts is because the defense refuses to accept responsibility and then makes up a bunch of bullshit, for lack of a better term, to try to excuse their conduct. And I don't think jurors like that.
Right.
And I think that they feel like they're being lied to. And I think because they feel like they're being lied to, they don't have any problem giving full verdicts on that.
And then you get the jury all fired up and get them angry at the defense.
Yeah, 100%. And,
You know, the other case I did that in, John, was a little more interesting one. That was the exact tactic. That was actually a retained foreign object. A needle was left in somebody.
So a doctor operated on somebody and left a needle?
Yeah.
No way.
Yeah.
So how did you win that case?
Probably this much skill and this much luck. I'm not quite sure exactly, but it was an interesting one.
I have a feeling there's more to it than that.
Yeah. So that was an interesting one because I remember client called me and said, send you a new case. And unfortunately, a needle's been left in a patient, just do some quick investigation, find out how much money they want, and we'll get this thing settled. Not the kind of case I usually send you, but we just need someone to handle this for us quickly. And so,
yeah. So the client was kind of saying like, yeah, this shouldn't have been done. I mean, obviously a needle should never be left in somebody, right?
Exactly.
Yeah.
There are certain events that are what we call never events, and that's one of them.
Yeah.
Right? But I went to the very first meeting and talked to the doctor about the case, and we kind of went through all that and explained all these, a lot of hospitals, they've got really good people working in them. They got little great policies and procedures, and some just didn't go right that day, but he explained the counts and how they do them, and they keep track of the, the sharps and the gauzes and the needles, and they just couldn't quite figure out, but a needle got left behind somehow, and, thanked him for his help and said, we're going to go try to get the case resolved. And he said, but before you leave, I don't think it hurt her at all. What do you mean? You got a needle sitting inside this person. He said, I don't think it hurt her at all. And I said, doctor, it's needle inside this patient, right? And he said, well, not actually. You're thinking like a sewing needle inside an operating room. We use all kinds of different needles. This needle is actually a curved needle, and the point of it was here. Yeah, more like a fish hook. And
I still don't want a fish hook at me.
Right. No, I would not want a fish hook in with me either. But he says, I told her when I did the original operation that there was 2 operations that I could do. One of them was going to be more extensive than the other one. It may solve your problems, and we can go that route, or we can try the lesser of the 2. She opted for the lesser of the 2, and so we did that operation. Unfortunately, we left this needle behind. She had a lot of pain and problems afterwards that she thinks now is related to the needle, but I think it was related to her underlying medical problems. I had to go back in and do the second surgery. I went back in, opened her up again to the second surgery, and there's this needle sitting there. And it just happened to be sitting underneath the skin and below where a lot of the nerves are, laying on some fat, essentially inside the body. I grabbed the needle and put it in the petri dish, if you will, and continued the operation, and I don't really think it hurt her.
So did this case go to a trial, a jury trial?
Yeah, this case went to trial.
You guys had to have offered money on the case.
Yes.
Right?
Well, part of these trials a lot of times is how much money does the other side want and how much risk you want to take. And so again,
it's all about risk, right? All about risk.
Plaintiff's lawyer thought, I'm going to go talk about this retained needle. The jury's going to be outraged and they're going to award a lot of money. And we decided to take the risk. So of course we admitted liability, like we talked about earlier. And
what did you say? How did you admit it? What did you say?
Well, we went in front of the jury and said, we understand that things like this are not supposed to happen. We talked about the policies that are at the hospital, the procedures that are in place that are at the hospital, how the nurses do counts during an operation, and how they, typically find everything. We really couldn't figure out what happened in this case because all the records were right, and it looked like that everything had been counted for, and somehow this needle just got left behind. And people are human. Sometimes they make mistakes, and we're sorry for that, but we don't think it hurt her.
That's it. And you won.
Yeah. So we also called expert witnesses, that came and they testified, and they talked about the location of the needle, and they talked about the fact of, where it was inside her body, where the nerve endings are and things of that nature, the operations that she had, and then explained to the jury that, yes, again, we're sorry. This shouldn't have happened. Something bad happened, but there aren't any injuries because of this. Doctor had to go in and operate for that second operation anyway for the other problems that she was having. Took the needle out and didn't cause her any problems.
Was it the doctor or the nurse or the hospital or what?
It was
the
case was actually, so when you're in the OR like that, the responsibility for counting all of the sponges and sharps and needles and things that can be left behind, that actually falls on the nursing staff.
Okay, so it's against the nurse. Were they likable?
Yeah, very likable.
Yeah, that's, I don't think it's the same case, but I remember hearing a story when I was young at Feiger's office about a retained sponge.
Yeah.
And this isn't that same case.
No,
okay,
not that case.
That was a different case.
Yeah.
They left a sponge in somebody, and then we always laughed because the plaintiff's attorney lost the case. And we kind of we would make fun of them and be like, dude, they left a sponge in a human and you lost the case. But, but that's a good example. Now, if you went in there and said, we didn't do anything wrong, and
I think the jury would have laughed us out of the courtroom.
right. And, so, I mean, this is an interesting issue because it comes up more and more. I had, I'll give you an example. I just had a semi case, Macomb County, massive semi truck. It blows this kid and sandwiches him. He literally smashes the back of this kid into another semi. So semi, the guy's the peanut butter and jelly in the semi sandwich, okay?
Ouch.
And he almost died. The back of the trailer came in to the cab next to his head. So if he would have been over 1 foot, his head would have been smashed. But obviously a great case from a plaintiff's lawyer's perspective. The kid's hurt. He's not at fault. He was stopped behind a semi and got rear-ended. We find out that the driver of the semi who smashed into him was on a medication called gabapentin, which the employer knew about, and the employer should not have been allowing him to drive, or at least not without some supervision, because he had high levels of gabapentin, which was to treat nerve pain, right? Chronic nerve pain, and MS in some cases, right? So the defense denied that they did anything wrong. Now we get close to trial, and I'm like, this is going to be great, okay? One thing that I see is the defense will not, in the beginning of the case, even though they have a decent grasp of the facts, we obviously don't know everything in the beginning, and they say, we're not responsible. 2 years later, as we're getting about to go before the jury, the defense says, you know what? We're just kidding. We are now going to say that we're responsible. I'll tell you what I do, and I have a motion on this. It's like 30 pages long. I say, no, it's too late. It's too late. I had to hire experts. I had to go and do a bunch of extra work. It's too late. Now, depending on the judges, some judges, especially old school judges, will say they can admit that they're responsible at any time. Other judges, and there's good case law that says you can't, will say it's too late. Or they might say, all right, you can say that you're responsible now, but the plaintiff can still put on their case. In other words, in that trucking case, what they were really trying to do was they tried to say, Judge, we're going to say we're responsible, so Mr. Marko can't tell the jury our driver was a bad driver. He was on gabapentin. He wasn't properly trained. He didn't have his DOJ clearance.
Keep all the juicy facts out of evidence.
All the good stuff, right? That pisses people off, and that they're going to, say, yeah, that's wrong what they did. So what's your experience with that? Have you had, do you wait? How do you do that? Because I fight it. I'll tell you, I fight it on my side of the V.
Constant strategy I see going on, both in cases that I litigate and in my mediation practice as well. People are talking to me about that all the time. Like, we're going to admit liability in this case, or maybe not. We're going to wait. And you're exactly right. Case law out there that says if you wait till the end, the judge is going to let all those facts in. They're going to let the plaintiff's lawyer talk about whatever they want anyway. And there's case law out there that says maybe that's not proper, depending on when liability is admitted, when it's not. So you got to kind of strategize that again. And every case is different. Sometimes you're admitting liability, but like in my cases, it wasn't just we're going to admit liability and let them try to keep the damages down. We were still going to try to win. We were still going to try to win that zero completely if we could. So on those kind of things, you want to admit liability earlier, I think, because you got that causation defense. Yeah. Sometimes you're just defending on damages, kind of to keep it down. Strategy you got to employ at different points in the case.
Yeah, and it sounds like, in this case, our guy was like, had broken bones and stuff. He was going to get something.
Right.
Right. Or I really would have had to screw that one up, I think. Really screw up, or the jury would have had to screw it up. Somebody would have to screw that up. But I've seen defense attorneys say also, well, look, we're at fault. We caused some damage, but let's be reasonable. That's a tactic I've seen a lot. Not that much, though, to be frank with you. It's I think
a dangerous one.
It's a dangerous one, yeah. But I don't like that either, because I'm going to go for the gold. I want to go for the gold. So when I hear I'm sorry, we screwed up. We made a mistake. Let's be honest about it. But let's keep the damages down. I don't like that because it makes things hard. But a lot of defense attorneys won't do it. By and large, I think they don't do it. I mean, I can tell you, John Eads, who now works with me, who I considered one of the top defense trial lawyers in Michigan, he would do it. And it would really, frustrate me because he would be sincere. I'm sorry, we screwed up. We made a mistake. Let's be reasonable.
I think it takes a talent to be able to do it on the defense side. And I think, guys like John and me, you get to a point in your career where your clients trust you to handle their really bad situations for them, right? So a lot of lawyers will go through their entire career. They'll never even be in a situation like that where they're going to be handling a case that is big enough or bad enough that they're even going to be contemplating all that kind of stuff. When you handle the big stuff for your clients, the catastrophic injuries or liability cases that are really bad, you got to be tactical about all those different elements and try to, sometimes you got to take some risks, and I hope you do well at trial. And sometimes you got to just think through all that stuff and figure out the best way to litigate these cases for your client.
Do you ever get pushback from the insurance company or from your client if they're like self-insured and you say, hey, I think we should admit that we're responsible, and they say, no, we're not going to let you do that?
I'm fortunate that most of my clients are, sophisticated businesses or in-house attorneys. And so we are working together from the very beginning of the case, strategizing all of the litigation points and what we should do. And so those are things we're talking about from the very beginning, kind of working through it together. So they obviously are going to listen to my advice. They're going to give their own feedback. We're kind of work through all those issues and generally kind of come to consensus on what we want to do.
Yeah, that's good. I had just one more quick on while we're on this topic, because we haven't talked about this, I don't think, before on the show. I had a med mal case, great lawyer. I won't say his name because I don't want to get him in trouble, but good guy. We became friends on in the medical malpractice case. Well-known plastic surgeon. A woman went in for a breast. She had been a mom, and so she needed her breast evened out. Essentially, I don't know what the technical term is, but he was going to perk one up, make it a little bigger, make the other one bigger, even them out, right? Well, he put the big implant in the big boob, and so the small implant in the small boob. So now the bigger breast became like ginormous, and the attorney for the defense said, we should admit liability in this case. Like, you put in the wrong breast implant. It's obvious, and the client, the doctor said, we should admit liability. I agree. But the insurer pushed back and said, I don't consent. We don't want you to admit liability. I think that's stupid. And I don't know.
John, I actually know about that case. You might have forgot this, but I think what that smart defense lawyer did is he said to you, what we got to do? We ought to go to mediation.
I forgot.
We ought to call Michael Dolenga and see if we can get this case resolved. So I know the lawyer and I know the case, and I was your mediator.
I forgot. I forgot that you mediated that case.
We worked through that one, and ultimately it got settled.
But to me,
and it should be settled.
That should have been settled.
Absolutely.
Don't you think though that was the case? Not to cast judgment on anybody, but that defense attorney had it right. Like in a case like that's so, you got to admit, I don't know. What do you think about that?
There are cases that I think one of the things that lawyers have a hard time with is when you go to law school and then you become a lawyer, you learn to think differently. You just think differently about the world. You think differently about life. And, you learn all this law and you learn to apply the facts as you see them to the law. And then they forget that everybody else isn't a lawyer. And those jurors that are sitting, in that box making the decision aren't lawyers.
Yeah.
And so they're going to bring their everyday experiences,
common
right?
sense, and their backgrounds, right?
So you bring your lawyerly stuff in sometimes, and you say, I can defend this case, and I can walk this line, and I can do this, and I can do that. Well, when
fight
you're
everything,
exactly, you're presenting that case to different people with different outlooks on life.
To me, credibility is king, and when you take unreasonable positions like that, you lose credibility. And when I tell, especially on the plaintiff side, I think we have, I think jurors are more skeptical of the plaintiffs because we're asking for money. On my cases, I tell them straight up, we're asking for millions of dollars. It's going to big case. So if you make one misstep, your credibility's gone. I think you lose, or you'll get a low cause. And so I just am firm belief. If I have somebody come to me and say, back when I was young, I remember I had this auto case where this guy would make all this. He said he made all this money bowling, right? And so he hurt his back and he said he couldn't bowl as well anymore. And so I made like a claim for like $1 million. I said he was going to be like a professional bowler, like Kingpin. And we had no receipts. We had no, it just was a stretch, but I was like, I got to fight for everything, and I think that's a mistake. You lose credibility. Going back, I would say, you know what? I bet you did lose money bowling, but look, dude, you don't have receipts. I'm not asking for it. I don't know.
Right. No, it's very true. And you know what? You also have to be aware of, and I know you are as a good plaintiff's lawyer, that the defense is going to find out everything about your client.
Yeah.
Right? They're going to look for those receipts. They're going to investigate them. They're going to look at their social media profile. If they post anything online. Sometimes they're doing surveillance, whatever the case might be. They're going to find it all out. And they're always looking to blow your credibility. And if they do, you're going to lose.
You're toast. You're toast. They blow your credibility, you're toast. That's why they say, I don't think the defense knows about this or whatever. I said, you better damn assume it. File a motion on it. Even if they don't know, it's better to be safe than sorry. And I've seen some defense attorneys not do that same thing. I had a star witness in a trial who they he was convicted, like a 4-time felon, convicted of embezzlement and all these other crimes and drug dealing and all this crazy stuff. And he was just not a good character. They tried to keep it out by not talking about it. I found out about it. It came out in front of the jury. There's nothing better from my perspective to blow somebody's credibility out of the water because everybody can see it. The face contorts. It's like, And
juries watch all that stuff and they judge all that stuff in the courtroom all the time, whether the credibility is about the actual case that's happening or something else that's happened in their life. And if they don't, defense doesn't have credibility, they're going to lose. Plaintiff doesn't have credibility, they're going to lose.
That's right. Yep. So what else what other crazy things? Have you ever had any have you ever felt endangered or anything in your career? I always ask for you've been practicing long enough. I bet you've seen some crazy stuff.
Yeah. I had the FBI come into my office one time. I've had the police come to my office. I had the guy that the only way I think to describe him as maybe a drug lord call me one time and demand some money.
Okay, these are good.
These
are cases gone wild. So where do you want to start with this?
The drug lord one's a quick one. I'll tell you about that real quick. So that was just a case that I was defending a case. It was a multi-million-dollar personal injury, wrongful death case. And, like most of these cases, we litigated it for 2 years. And
they take a long time.
And
so the plaintiff was dead. He had passed away.
Yep, exactly.
And so the money then goes to the family, right?
Goes to the family, right. And he had left behind a wife and several kids and stuff. And he was a high wage earner in that. And so it was a big case. And, we settled it for several $1 million. And the case got done. And couple of weeks after the case was done, I got a phone call. So the case
is done.
Done, settled.
Did you send the checks out to the...
Check had not quite been sent out yet.
Okay.
As you know, John, courts have to approve these settlements when someone passes away to make sure that they're in the best interest of the estate.
So it's all fair.
Yeah, it's all
and
fair.
Sometimes people fight over the money,
right.
which is an ugly part of the...
Yeah.
But...
So all that stuff is pending. We've got the checks. We're getting ready to send those over. The judge is getting ready to approve it and everything. And I got a phone call, and the person says, I understand you just settled the, we'll call it the X versus Z case.
Okay.
And I said, yeah, we did. Who is this? And he said, you don't need to know who this is.
What?
Yeah.
What?
I want the money. What are you talking about? He said, your client bought a bunch of drugs from us. And owes us a lot of money, and we want our money, or we're coming to get it.
He said that to you?
He did.
Like a threat?
Big time threat.
Like, I'm going to come. And this wasn't some prank call. I mean, obviously this guy...
I thought it was. When I thought it was, this is one of my buddies goofing around with me, right? This is a prank call. And I said,
you didn't have the money.
I didn't have the money. And what I realized, if there was any truth to this call, I said, hold on. My client is the defendant. They're paying the money. So I don't know what you're talking about or who owes who what. And he said, person involved in this case, I sold him a whole bunch of drugs and he owes me a whole bunch of money and I want it.
The dead guy?
Yeah.
Oh, so he mixed you up with the lawyer for the dead guy?
Exactly.
Oh my God.
So I just said, you're talking to the wrong lawyer. I don't know what you're talking about. Leave me alone. And I hung the phone up.
Oh my God. So no, that's crazy.
Yeah.
So I wonder if the guys ever got their money.
I have no
And I wonder
idea.
if he called the
don't
plaintiff's
wanna
lawyer.
know.
Yeah,
I don't want
that's
to know.
like one of those
I never
things.
asked the
It's like,
plaintiff's
I
lawyer.
don't ask any questions.
Exactly.
I don't want to know.
Put the red rope back, tie it up,
Tie
put it back
up,
on the
put
shelf, and say,
take
I don't
it
ever
to
want to see
storage.
that file again.
Take this file to storage.
Right.
Yeah, that's crazy.
Yeah, yeah.
I mean, look, in this business, there's high emotions. There's normally not that kind of crazy stuff, although there
Right.
can be. But, I've had clients threaten me. It's very rare. I mean, 99.9% of the time they're happy. But I've had defendants threaten me.
Right.
If things don't go well.
Well, hopefully you'll never have the FBI threaten you.
God,
happen?
I hope not. If they're listening. So yeah.
That one happened to me too.
I ran into one of my buddies the other day. I said, "Oh, what are you doing now?" Because he was like in the Penobscot building when I used to work there. We just ran into each other on the street. He's like, "Oh, I'm with the U.S. Attorney's Office now." I said, "Oh God." I said, "Hopefully I'm never going to be on one of your cases." And he smiled and he looked at me and said, "John, and hopefully I'm never going to be on one of yours." And it was kind of like, okay, touche. I got it.
Sounds like a good friend to have.
Yeah,
though.
exactly.
Yeah,
Exactly. So what happened? So
this is another one, just young lawyer story, right? I was representing somebody who was bringing a claim or wanted to bring a claim against a pretty well-known business person in the Detroit metropolitan area. Big real estate guy, and owns some bars and some restaurants. A lot of
So
real
wait,
estate
so
business
you're a
stuff,
plaintiff's lawyer at the time?
Plaintiff's lawyer at the time. Yep.
And your client wants to sue who? Well, you don't have to give a name, but like a powerful person.
Yeah, powerful. We'll call him a real estate
mogul guy.
Yeah, I'm just like mogul's a good word, John.
Okay.
And she felt like she was being harassed by him. She worked for him
Sexually.
Yeah.
Okay. Yeah.
And so she wanted to bring a claim against him, and we were investigating the claim, and we had sent a settlement demand letter saying what our claims were and what he had done wrong, and we're asking him to pay some money, or otherwise he was going to get sued.
Standard.
Yeah, standard stuff. We figured he didn't want to go to litigation. She didn't really want to go to litigation. Try to get it resolved pre-litigation, right?
Yeah, those are, I think, a lot of cases are hard to resolve without a lawsuit. But I think those employment cases, those are like some of the most targeted cases to be resolved for everybody.
Right.
Because the woman or man or whoever doesn't want to have to put their dirty laundry out there. Neither does the entity. So.
Right. Yeah, so as we were working up the case, I got a phone call one day when just
Did you
Wednesday
file
morning.
the lawsuit yet?
We had not filed the lawsuit yet. We were still in some pre-litigation negotiations, and phone rings and on that case, and person gets on the line with me and introduces himself as an FBI agent, and he says, "I understand you're getting ready to bring a claim against so and so," and I said, "Yeah," and he says, "We want your file." What do you mean you want my file? I said, "We want your file."
This was the FBI.
The FBI.
Did they show up?
Yeah. Again, remember we talked earlier about being the young lawyer. You kind of don't quite know what to do. You be a little more aggressive. And of course, I'm not giving you my file.
Yeah.
Said, yeah, you are. And I said, "Oh, it's attorney-client privilege. I'll go to jail before I'll give you my file."
Are you
this
even?
kind of stuff.
I don't think. Are you allowed to give the FBI?
Well, I
client
found
file?
out you are, John, because he says
I
to
didn't
me,
know that, to be
Yeah,
honest. If the
yeah.
FBI came and said, "I want a client file," I'd probably tell them no until I saw a law that said I need, because I didn't know that's a thing. Did they have a warrant? Do they have to have a warrant or something?
So that phone conversation, I tell him I'm not giving you my file, attorney-client privilege, that, and he just says, "Son, we're the FBI. We'll be at your office this afternoon."
No way.
Yeah.
So how old are you at the time?
Oh, geez, I'm just shortly out of law school, so I'm 25 years old. Yeah.
Wow.
Yeah.
So did they show up?
They showed up. Fortunately, what I did is I called somebody, do what every good lawyer should do or smart lawyer should do when it's not your area of the law.
I would call one of my criminal defense buddies.
Exactly.
Yep.
So I got a hold of somebody, and he knew a little bit about it. And what we ended up doing is when the FBI showed up, I had divided my file up, and I basically into some investigative materials that we had that was going to be responsive to. They showed up with a subpoena, saying you got to give us stuff.
Like a fax subpoena.
Exactly.
Yeah. Okay.
And then some stuff that was I felt was really strongly privileged communications between my client only.
And yeah. So what I'm hearing you say is that, if I understand this, they can get all your factual materials, right? Like a witness statement, or I don't know, the Monica Lewinsky dress with the stain, or any of that type of stuff, but they can't get your mental impressions and your communications between you and the client.
Right. And I think they, of course, have to have a reason for it. And so, of course, not known to us, the FBI was also investigating the same person for some wrongdoings that they thought. So they had a reason.
The defendant, the mogul.
Yeah, exactly.
The mogul. Okay.
Exactly.
So they wanted information for their case.
Exactly.
Yeah. Okay. Yeah.
So,
did they show up? Like, how many showed up?
Sometimes a lot of this stuff, right, the best way to do this is just to kind of figure out what the common ground is, especially in situations where, I don't know what the repercussions are going to be for me with the FBI, for my client. So 2 guys showed up, and what we ended up, as I said, here's what we're willing to give you that I think is responsive to your subpoena. And I got permission from my client, of course, to release that information. And then, I can't show you what's in this file, and I don't think I should have to, and I think it's all privilege between me and my client. They took that stuff, took copies of all that stuff, and apparently that satisfied them because they never came back again. We ended up working out a settlement for my client with this mogul, and I don't know what problems he ended up having with the FBI or not. I think he ended up working out a deal with them too.
Yeah, but that's not a fun experience.
Yeah,
right?
It was not fun at all.
So you guys were kind of like on the same side. You probably didn't even know it at the time,
right? Exactly.
Yeah. I mean, I've had cases like corruption cases, and they usually are the employment context. Like right now, it's been all over the news. We're suing the city of Hamtramck for their city manager and a police officer. And the FBI is also investigating the same defendants in that suit, right? So if, we came across information, it could assist the FBI in that case, right? So
you guys can help each other out.
We can help each other out, right? So that's interesting.
We could have probably as well, but I think in my situation, mine was a harassment case. Their thing was totally different. What they were
like
investigating,
corruption or something.
Exactly.
Did the guy go down? What happened?
I don't think he did. I think he cut a deal with them as well.
Yeah. That's crazy. You never want to have have them show up at your office.
I had the police show up once too, but I actually invited them.
What happened? What happened?
This goes back to our situation we're talking about. The defendants are always going to find everything out about everybody.
Yeah.
So simple case was just a car accident case, not that big of a deal. But there was a star witness that was going to testify for the plaintiff just about how the accident happened, help them, prove liability. And so a deposition was set up that, as we talked about earlier, you've got to take these depositions during the process of the case so that everybody can learn what people are going to say. And so Thursday morning type of thing, set up a deposition to take place in my office. Well, we knew that this witness that was going to help the plaintiff out in his case had a subpoena, had a warrant out for his arrest.
Wait a minute. Who had the warrant out?
So there's a plaintiff and the defendant. This is a witness who's going to help the plaintiff's case out.
All right. So a third-party witness.
Third-party witness, right. There's a liability dispute as to who's caused this accident. This is a witness who's going to testify, my client caused the accident. We're defending the case by saying, nope, the plaintiff caused the accident. So we knew this witness was going to help them. We knew they had a warrant out for their arrest. We called the police.
Oh, that's dirty, dude.
Yeah, it was a little dirty, but you got to fight dirty sometimes, John.
So the police came and arrested the person?
Yeah, so he comes to his deposition, he comes to my office, sworn to tell the truth, all that kind of stuff, and he gets about 10 minutes into his deposition and police roll up into the parking lot and he can see him out of the corner of his eye out the window of my conference room. And
what was his warrant for?
I don't even remember what it was for.
Yeah.
So he's getting a little nervous, but he keeps testifying. Deposition's proceeding. 2 police officers get out. They're walking towards the front door of the building, and as they get real close, he just jumps up from the deposition and he runs.
No way.
Yeah, he knew they were coming for him.
No way.
Yep. So it was really funny though because it was like a scene out of a movie. At the time, our office building was under construction.
Yeah.
And so like our office was done. There was a couple other offices across the hall. They were done, but half the building still wasn't done. So it's like in a house where you see like sticks, or in a commercial building where just the metal's up and the suites aren't built out yet. So the cops come into the building. They come to the front door. This guy runs out the back door of our office and he gets over into the area that's under construction and he's running and he's jumping over sandbags and running in between poles and stuff. And the cops are chasing him all around the building. And eventually they caught him, tackled him, cuffed him, and walked him out to the squad car and drove away.
Oh, that's crazy.
Deposition
now,
over.
Did you know that there's a court privilege that gives you immunity on the way to court? I don't know if it applies in a deposition.
No, I didn't know that.
But, well, I know it because Jim Razor tried to serve me a subpoena in a lawsuit I had against him, and he tried to serve me with a subpoena in a courthouse, right? And so I
knew it was in the courthouse.
In the courthouse.
Okay.
But I think
on the way to the courthouse too, you're saying?
Yeah, on the way to the courthouse to testify at a proceeding. So I don't know if that would apply to a deposition or not, but there's a court rule or there's a law that says that you cannot serve someone or arrest them or serve a warrant, I think. I got to look at the language again.
Right.
On the way to testify to or from a hearing. But the person has to assert the privilege at the time. So in other words, like when I was literally like walking into the courtroom and a process server tried to serve me with a subpoena or complaint or something. I don't remember what it was. And I said, you can't do that. That's illegal. I'm asserting the privilege. And he said, I don't know anything about a privilege. And then I told the judge, and the judge looked it up and said, Marco's right. There is a privilege. You can't do that. But you have to say it. Now, I think that's a little tough because most people, like, you didn't even know it.
Right.
And you've been practicing longer than me.
Right.
Right? And I didn't even know it. Somebody told me, they said, Marko, assert a privilege. There's a privilege. Here it is. And I did. But it's interesting.
Sometimes the police don't know it either.
Sometimes the police don't know it
Sometimes
either.
the police are pretty savvy too, and they do know this stuff. Like the cops in my situation, maybe they weren't even going to do anything. Maybe they knew by their presence that guy was going to bolt, and then once he leaves the deposition, if the privilege does apply, then they can get him.
Yeah, that's true. But you have to assert it at the time that they're trying to arrest you or serve you with a warrant or serve you with legal process. But that's so our viewers know if you're on the way to court or on the way back, I think it just applies to those two. Assert the privilege. There was another one. This lawyer got into a dispute with another lawyer down in Tennessee over a fee. And so this was kind of dastardly. So it was a Michigan lawyer who I know. And so they set up a mediation, an in-person mediation. And they set up the mediation in Tennessee. But the mediation was a ruse, right? He needed to get personal service, and he had to do it in Tennessee. So the lawyer flies down to Tennessee, goes to the mediation. The mediation was a ruse. He got served at the airport when he was headed home. The guy was waiting for him. So it was a ruse to serve him with that. So
tricky stuff.
Interesting.
Yeah.
Interesting stuff on that. And we just had another case that we just did where the defendant threatened my guy. My guy had a warrant out for his arrest, but it was a stupid warrant. It was like he didn't pay a fine or something. And so the fine was, because of the fine, they issued a bench warrant or something. You know what I mean?
Yeah.
And so they said that at my guy's trial on his case, he was a plaintiff, that they said, we can't, we can't help it if he gets arrested in the middle of the trial or something. So I brought it up with the judge and I said, Judge, there's this statute. You cannot do that. Like, we're not going to have this over a parking ticket or whatever it was. And the judge said, yeah, we're not going to.
Yeah, I think it was something minor like that too. The judge is going to cooperate with you, right? Let him have his day in court and take care of that later.
Yeah, I'll take care of it later.
Yeah.
Yeah. All right. He's telling me we're almost out of time. So do you got one more crazy story?
Oh boy. I think we've covered them.
What about a
John.
mediation?
Yeah.
You like, what do you find like the hardest things to deal with in your mediation practice between the lawyers?
Oh, with mediation, it's just everybody wants to fight, right? Everybody, and the mediation process is different, right? Mediation is trying to, it's a bringing together of people, kind of being that peacemaker, trying to help people see why cases are being brought against them, trying to help the people that are bringing the cases understand why people are defending cases. And lawyers are competitive. Lawyers like to fight. I've had lawyers try to have fist fights with me after motion hearings and stuff like that. Fortunately, not at mediation. I did have somebody throw a chair at me one time in a mediation, but
You did?
yeah,
An
yeah,
actual chair?
an actual chair. But you know the funny part, John? It was on Zoom.
No way.
It didn't hit me.
Was it record? Wait, he was on the other side of the camera?
Yeah.
Okay.
He just got a little angry and so
Threw a chair.
You got to keep people. You got to calm them down in mediation. You got to talk
Dude,
through
how
their
are
issues
you
and
getting
emotions,
people
so.
that? You don't seem to be. Maybe it's just I've never seen you to be the kind of person to really get people to throw chairs at you. Now,
Well,
look, people throw chairs at me all the time, but
I think I wanted to throw a chair at you a couple
Yeah.
times. Yeah. I think, again, lawyers are competitive. So I've motion hearings and trials and stuff like that where I've had people, like, let's take this out in the parking lot. I'm ready. Let's go. Dolenga, fist fight, that kind of stuff. I just think sometimes they're losing and they know they're losing and they get angry, right? And so they don't know how to control their emotions because they're emotional or they're competitive, whatever the case might be, and they're just going to take it to the next level.
Yeah.
And in mediation, again, people are just emotional and, it just kind of happens sometimes.
I still get upset. I mean, I just did this Kroger trial, which we'll talk about on another show. We don't have enough time today, but it was, a 2 or 3 week trial, high stakes. We ended up getting a $77 million verdict. But I became very upset at the defense attorney during the trial. But I don't handle it by like throwing things or yelling it or doing that stuff anymore. My thing now is if I get that upset, I put them on the sideline. I said, you know what? I'm not gonna. I really don't appreciate how you behaved and what you did. I can't talk to you now for the rest of this trial. I'm going to talk to one of your partners, as for better or worse. I said, I can't deal with you. It's bad, and I got to be in a good headspace in front of a jury, right? And you can't do that if you're being consumed by personal animus. Yeah. So
I've had lawyers in trials where a lot of times I'm sure like you handling bigger cases, right? You bring a team of people with you, right?
Yeah.
So I've been against people where they bring teams to against me as well. And like the second, third day of trial, I've realized that one of the lawyer's jobs in the courtroom is solely to try to antagonize me. And is solely to try to distract me. Like he's got the main lawyer, presenting the case and doing stuff, and the second person or the third person that's there is, either causing problems with the exhibits or trying to distract me the whole time, stuff like that. So you're right. You just got to rise above that and stay calm and be good in front of the jury, be good in front of the judge, and remain professional if you can.
Yeah, I mean, I think a lot of times those tactics can backfire because jurors are smarter than I think popular culture gives them credit for. And I think that they can see through most of the bullshit most of the time.
And they take their job really seriously.
They do.
Yeah.
They do. I mean, but you always hear the stories. I mean, do you remember like the Clarence Darrow story? He had a cigar. This was back when you could smoke in courtrooms, and he would put a wire in his cigar. So he'd take a metal wire, put it down the middle of the cigar, inside the cigar. So the ash would never fall off. It would kind of, you know how cigars will ash and then you like click it and the ash will fall. So it'd have a cigar full of ash. And the popular story was the jury wouldn't listen to anything going on because they're staring at this cigar waiting for the ash to drop off because it's like all the way down at the end.
Right.
But,
sometimes they fall for that stuff.
Yeah.
Sometimes they
don't. More
don't.
often, I think they get it right. But,
yeah.
Hey, Michael, great to have you on the show.
My pleasure.
Good
it was
to
a lot
see
of fun.
you, and thanks for thanks for being here and your good work. We don't have a lot of defense attorneys on the show, but you're a great guy. I have a lot of respect for you, and you do great work for your clients.
Appreciate that, John. Good luck to you too.
All right, everybody, it's been another great episode of Cases Gone Wild. Thank you to Michael Dolenga to being on the show. It was a great show. We're going to see you here in another 2 weeks. If you like the show, please share it with your friends and give us a thumbs up. Remember, if you or somebody you know needs help, please reach out to us, markolaw.com, or give us a call. We have a brand new number, 313, all sevens, baby. That's 313-777-7777. We'll see you in another 2 weeks here on another Cases Gone Wild.